Hello, my name is Sarah and I'm the staff attorney with the Justice and Accountability Center. This video is meant to provide information only on a person's eligibility for an expungement based on Louisiana laws. This is not a substitute for legal advice, and your eligibility will depend on the specific convictions, charges, and dates associated with your case. We strongly encourage you to collect your court paperwork and to speak with an attorney about your eligibility before you file or pay for an expungement. You can use this video, though, in our how-to guides available on our website to help get you started as a first step. Additionally, if you're interested in free legal information and advice specific to your case, I encourage you to follow us on social media, sign up for our newsletter, or visit our website for upcoming events where we will have volunteer pro bono attorneys meet with individuals to go over their court paperwork and help them fill out the expungement packet if they are eligible. The first step for this process is going to be to collect your court paperwork. In Orleans Parish, this means that you would ask the clerk of court for an expungement packet, or you can call the court to make this request. In all other parishes and in those clerks of court's offices, you would be asking for your bill of information or your sentencing minutes or the disposition of your case. If your case never went to court, you would need to get a background check from your parish sheriff and information from the DA's office for an attorney to determine your eligibility and help you fill out your paperwork. There sometimes are fees associated with this paperwork, so you should call the clerk of court or the parish sheriff so that you understand what those costs would be before you make these requests. A criminal record in Louisiana is any time a police officer or cop puts pen to paper on a person, and that could create a summons, a citation, or an arrest register for that person. This record would then follow the person through the DA's office, up through the courts, and potentially all the way to the Louisiana State Police as the criminal record. This is the record that we are referring to when we talk about expunging a record. Right now in Louisiana, there is no automatic way to expunge a record, and this would mean that if you have not gone through the expungement process, your record is still available for public view. An expungement itself is the sealing of that record from public view. It does not destroy the record. However, it would allow for you to keep this record from people like employers or landlords down the road. The forms that you would need to file your expungement are standardized across parishes and available online. They're on the JAC website. They're also on the Louisiana Clerk of Courts Association website, potentially on your local Clerk of Courts website, or available in your clerk office. You do not need an attorney to file these forms, but again, we strongly encourage you to speak to an attorney prior to filing your expungement. Now, when you become eligible for an expungement, again, depends on when your case ended. And that could be when you came off of probation, parole, or finished a sentence of incarceration. And we talk about that as the cleansing period that you would need before you are eligible. Keep in mind, too, that there are reasons a person can come off of probation or parole early, or potentially have a sentence of probation or sentence extended. So that final date when your case closes and you no longer are on paper are going to be when you start to have to count from. There are certain offenses or criminal records that have no waiting period. Those include arrests that did not result in conviction if the charges cannot be brought back. You can contact your DA and get a refusal letter if you did a diversion program and were successfully terminated and those charges were dismissed, or potentially if there was no outcome in your case and enough time has passed under Louisiana law that those charges cannot be brought back, you would have an arrest record that needs to be expunged. There are also no waiting periods for convictions where a person received a first offender pardon and has no later convictions, or a person received an 893 or 894 deferred sentence and had a set-aside granted. Keep in mind that for first offender pardons, it is automatic, but it does require that all court costs have been paid up front, and a deferred sentence of probation requires that you satisfactorily terminated your supervision or probation. Additionally, the law changed in August of 2020, and it used to be that you may have to wait 5, 10, or 15 years between your eligible expungements, so you could really only do one at a time, maybe two at a time. Now, you're eligible to file as many expungements as you are eligible for and can pay for under the law. There are no waiting periods between these expungements any longer. The two limits on that, however, though, are an 894 set-aside can only be granted once every 5 years, and an 893 set-aside can only be granted twice in your entire life. For misdemeanors, there is a 5-year waiting period from when your sentence ended, and that cleansing period requires no new felony convictions, and you cannot be under a bill of information or have pending felony charges. There are certain misdemeanors that are never eligible for expungement. The first of these is a felony sex offense arrest that resulted in a misdemeanor conviction. Even if you have no sex offender registration requirements, you can never expunge that misdemeanor conviction. But you may be eligible for an interim expungement of the felony arrest record. You also are not allowed to expunge a domestic abuse battery conviction or a stalking conviction. These laws have changed in recent years, so it's possible you were told at the time of your conviction that this could become eligible, but unfortunately, under current law, these charges are never eligible for an expungement. For felonies, it is a 10-year cleansing period from when you came off paper, and you can have no convictions whatsoever of any kind. You can have no new misdemeanors, no new felonies, and no charges pending against you. You are ineligible to expunge any record that is called a crime of violence, and that's defined under the law that you see here, with a few exceptions. Convictions for aggravated battery, second-degree battery, aggravated criminal damage to property, simple robbery, purse snatching, or illegal use of weapons can become eligible after 10 years. The law used to require 10 years of work experience, but again, in 2020, this law was changed, and there are no work requirements associated with these expungements any longer. All other crimes of violence, however, are never eligible for an expungement. Additionally, any sex offense convictions that require registration or that are defined as a sex offense under the law are never eligible. Neither are distribution of drug offenses, unless you have a first offender pardon, or domestic abuse battery convictions. And any charges that involved a victim under the age of 17 or any registration of any kind are also never eligible for an expungement. I've mentioned the first offender pardon, and for people who need this letter, it is automatic through probation and parole when you've finished your sentence and your court costs have been paid. However, the name is sort of a distraction because it is not in fact a pardon, and it is not the same as an expungement. It is not the same as a gold seal pardon, and it doesn't undo your conviction in any way. It simply is a letter that acknowledges your sentence is over and that your citizenship rights have been restored to vote or hold office or work. It does not restore any firearm rights. That's separate, and we strongly encourage people to speak to an attorney about the conviction they received and when and how their firearm rights may be restored. An expungement in Louisiana may cost you $550 or more currently under law. There is a fee waiver available at the discretion of the district attorney's office, but that only applies to expungements where the charge did not end with a conviction, you have never had a conviction on your record, there are no pending charges against you, and you did not complete diversion. Unfortunately, if you have a conviction, you will have to pay the required costs. They are $250 to the Louisiana State Police, $200 to the clerk of court, $50 to the parish sheriff, and $50 to your parish district attorney. If you had a DUI conviction, there are extra costs associated that you would have to pay to the Office of Motor Vehicles. Now, additionally, the timeline for an expungement is that it is not immediate from when you file your petition. If you require a motion to set aside under Article 893 or 894, there is a 30-day window where you should have a court hearing scheduled. A set-aside does require a court hearing. In about 30 days, you will have to go and have that motion to set aside granted before you can proceed to the next step with your expungement. Additionally, those are free to file. You do not need to pay any money up front for those. If you didn't need a motion to set aside or it was granted, and you file just your motion for expungement, there is a 60-day window. In those 60 days, the clerk sends your records to the district attorney, the arresting agency, or the Louisiana State Police, and they may object or oppose your expungement. You would get notice in the mail to have a hearing, and you would have to go explain why you believe you're eligible, which is why we strongly encourage people to speak to attorneys first. The money that you pay is not refundable if your expungement is denied. Some courts will also require a hearing to grant the expungement, simply putting it on the record that after 60 days your expungement was granted. You should contact the clerk of court or call the court office to make sure that you have a hearing scheduled or to find out when your expungement was granted and signed. When your expungement is granted, it is extremely important that you get a certified stamped copy from the clerk of court's office. Once these records are sealed, even you cannot get another copy of this expungement record. When you have that copy, you must keep it in a fireproof, waterproof place, put it in your email, put it on the SIM card of your phone, keep it in as many places as possible because you may need it in the future and you will not be able to get another copy. Additionally, every individual agency that has a copy of your record, from the police or the sheriff, the district attorney, the clerk of court, and the Louisiana State Police, are required to remove that record from public view. The Louisiana State Police will send you a certificate of compliance in approximately 2 to 3 months that acknowledges that they have sealed your record. All other agencies will not send you any notice, but are required to follow the order given by the court. Now, an expungement is a sealing of records, so that means certain people and agencies will always continue to be able to see your records even after they are expunged, but the record will show that it has been expunged. So any law enforcement officer or district attorney or police officer will always be able to see expunged records. Additionally, some state licensing agencies will see expunged records, and employers who have oversight or leadership of minors, like schools, daycare, coaching positions, all of them can also see expunged records. The example that we often use is that the Nursing Licensing Board will be able to see an expunged record to determine whether or not you can be licensed as a nurse in the state of Louisiana, but the doctor's office or hospital or wherever you are going to be employed will not be able to see your record to determine your eligibility for employment. We also mentioned pardons and how they're different from expungements. An executive or a gold seal pardon is actually granting you clemency. It returns you to the status of before your conviction as if you were never convicted, forgives the crime, and restores all rights. Those include firearms rights and other associated rights. These require an application, an advertising, and hearing before the Board of Pardons and Parole. If the Board of Pardons and Parole does agree with your pardon, it is then sent to the governor's office for signature, but this is completely at the discretion of the board and the governor. There is no timetable, and it is a process completely separate and apart from an expungement. So thank you for watching this video, and if you have further questions, please visit our website, jaclouisiana.org, to look at our how-to guides, and we hope that in 2021, our website will also have an eligibility screening app where you can kind of follow the process to see if your specific charge may or may not be eligible based on time. But look for us at future events, and we'll be happy to help you with your eligibility screening.